Okay, today we start with the remedies. Now, today we start with the tort remedies on page 1. So, I think if we have let's say contract, tort, normally when we file the lawsuit against third person, I think we can file the lawsuit in the cause of action for contract, tort, criminal law. But many times, let's say contract will maybe a breach of contract. However, let's say even in contract, if this was let's say misrepresentation, maybe fraud, let's see, or sometimes let's say, I think breach of contract also include, let's say, non-payment of, let's say, promissory note. Let's say here defamation, negligence, liability. So when we actually look at different cause of action, pure contract actually breach will be breach of contract, like breach of promissory note, or let's say this person he received the merchandise but he's not paying the money. But other cause of action like misrepresentation, fraud, defamation, negligence, product liability, those are more cause of action for tort. So the tort is basically we have been harmed some way, injured, or our reputation has been injured, we were cheated, somebody gave us the wrong information, we purchased the products, but there was something wrong with the product. Those are all belong to tort. So maybe in remedy, there are different type of remedy for contract and different type of remedy for tort. Because let's say if somebody supposed to, in contract breach, let's say somebody's supposed to deliver some merchandise, but he hasn't. Then I think when we learn the contract, the breach of contract, then maybe remedy at the time was, we used to call, let's say, cover. Cover is somebody supposed to deliver some supplies, but he didn't. So we were not able to manufacture products. Then what we do is, let's say this was a contractor making a house. The subcontractor who's supposed to supply wood frame breach. breach means he delivered the wrong products or he did not deliver the products. Then what I could do, let's say what the person could do is he could buy some other products. Let's say now he's trying to buy urgently, so he's paying higher price. So he is basically purchasing another products to replace what he's supposed to receive at higher price. Then he build the house. Then he's gonna basically file the lawsuit for differences. That his original contract price and the price he paid emergency. So that's basically pure contract remedy. Pure contract remedy is basically whatever the damage it incurred, whatever the amount we spend more because the other party did not fulfill the contract. So we actually, when we gonna go over UCC, actually we're gonna go through that remedy portion in UCC once again. But in tort, basically, let's talk about the negligence. Negligence is here. Let's say we got injured by automobile accident. So we can ask for compensatory damage. Mostly tort damages are compensatory damage. Normally, general damage is basically, general damage include your hospital bill and your pain and suffering and your repair. So in general, basically damage will be normally, it includes three types of damage: hospital bill, pain and suffering because I fell, and my repair bills. Special damage normally happens when you are not able to work. Let's say missed wages. So some special damage, you have to prove something special, that because of the automobile accident, you are not able to work, so you won't get compensated for your the paycheck that you didn't receive. So that can be more special damages. Now, so normally I think for negligence, probably that's about it. But let's say if it was a defamation. If it was defamation or fraud, let's say if we can prove, let's say in defamation, let's say if we can somehow prove, let's say bad intent of the party, then we could actually ask for all these. Here, if it was defamation and fraud, pain and suffering is your medical bill you spend for your psychological damage. So if it was a fraud and defamation, this will be more your pain and suffering, your mental damage. If you missed your work because of that, special damage. But you could also ask for punitive damage. Punitive damage is that when this person had a bad intent, you are asking court to punish him for his bad act. So punitive damage, you can say, you can memorize as punishing damage. So you can ask for court. Sometimes these punitive damage can be much more bigger than this damage, compensated damage. Let's say a newspaper company, let's say knowing that the story is false, knowing that story was not true, said Brad Pitt have a male sex companion. Then basically it ruins his image. So let's say Brad Pitt has a big movie contract, and when his reputation got bad, he lost his contract. So he can ask for basically general damage and special damage. Then he can also ask for punitive damage because that party had bad intent. And if you can prove malice, then maybe this punitive damage might be 100 times, even 10 times bigger than this damage. Even let's say this fraud, somebody intentionally trying to basically deceive you. Let's say, then let's say maybe this damage might be only 10,000, but you can ask this for 100,000. So punitive damage, the problem is punitive damage is decided by judge. Normally toward the end of the complaint, we ask for how much compensated damage, how much special damage. Then we say we like to also judge to award us punitive damage, whatever the amount that judge think is appropriate. So we don't define the dollar amount, but punitive damage can be much bigger. So depends on what kind of case. Normally, if it's a pure negligence, we cannot ask for punitive damage. But if it was gross negligence is more serious negligence act, then we can ask for punitive damages. Let's say, especially in case of, let's say these, who's a football player who was in jail, killed his wife. Just slipped up from let's say,
O.J. Simpson.
O.J. Simpson, yeah. Now in O.J. Simpson's case, he lost civil case, right? Yeah, he won the criminal case, but he lost the civil case. Now in those cases, the value of life is hard to determine, but because it was murder, the punitive damage will be much bigger than general damage, right? So that's why punitive damage can be, let's say, 30 million, when general damage can be only 5 million. So because of the malice element, because of that bad act, bad intent. Okay, so now in the tort damage, let's take a look at this. And the tort damage, start from A1 at the beginning. In tort case where plaintiff has suffered a loss or injury, or the award of money damage is the standard and characteristic legal remedy. This remedy award is intended to compensate for loss and thus put plaintiff in as good position as if injury had not been inflicted. So basically, Now, the terminology they're using is a little confusing. There's another terminology they use, say, plaintiff will normally be made whole by receiving compensation for actual loss. So, if somebody was injured, the thing is, let's say somebody got injured and then he lost a leg, and he will definitely get very high compensation, right? And when you think about this term, then how can we put him as in good position as if the injury has never been inflicted? Now, if this person lost his leg, then how can we put him in the position as good position as, you know, that before he lost a leg? So it's difficult thing, difficult to actually. How much do we value of his lost leg? That's the thing. And many times it all involved in how old this person is he not able to work any longer? And also there is other compensation of so-called loss of companionship. Let's say this person, loss of companionship is, let's say he is no longer able to do sex with his wife. There is compensation for loss of companionship. So, let's say this person died during airline crash. Then of course there are two different type of damage. This person who died, wife can claim for his basically. See, wife can claim for his basically pain and suffering. You have to imagine that wife is saying, before he died because of the airplane crash, he must have felt so much fear and and all that anxiety and all that. And wife also, I mean, he's not here, so his wife is getting compensated for him. So wife will get this pain and suffering for husband. So that's for husband's side. So for, let's say, for husband's wife, so for, now this person is this person. For husband, it will be for his pain and suffering. Now there's no medical bill because he died. Yeah, so there's no medical bill. But wife is filing a loss for his pain and suffering. And wife is filing a loss for she lost her husband. So she wants to get compensated for loss of companionship. Now I no longer have my companion. So yeah, she like to get compensation for both of them. Now let's say this airline had similar accident about 1 year ago, and government, let's say the airline, the control, let's say their inspection, they normally have a rating, right? So their rating was very low, and the airline, whoever regulate, said that you guys need to do, let's say, you guys need to check your airplane every 3 months. And if there was any violation, if they can find any violation, then now she can ask for punitive damage. Because not only negligence, once we can prove any bad intent, even gross negligence, If it was just pure mistake, no punitive damage. But if, let's say, this airline received warning from F somewhere, whatever the regulating agency, but they did not comply, then there is punitive damage because they violate the law. So whenever there is any of those accidents, then it's attorney's job checking every detail if they violate anything, if they missed any date. Let's say this was, this is, let's say, big company. Let's say Best Buy. And Best Buy is delivering merchandise everywhere. And one of the driver who was delivering refrigerator was drunk. And he's, now that's again violating law, right? So let's say then this truck killed one of the passengers. If there was no drunken involved, then basically that's all they're gonna get. But if this driver violated any law, he drank and drove, then there's punitive damage because he violated the law. And who paid for it? Employer. Let's say if this guy is not working, he has to pay for it. But the problem is, if he's working, there was accident during his working hour, employer has to pay for it. So that's the big, actually, insurance coverage. That normally, insurance coverage will have a maximum amount, right? I think even in automobile insurance, even though we kill somebody, I think maximum coverage is $100,000, isn't it? I think even though I think their maximum coverage is like $100,000. So normally insurance agent will ask me, do you want to increase your benefit in case you have to cover gross big accident?
And then umbrella cover.
Umbrella.
Cover everything.
Yeah. Then you can increase your coverage. But so if you have a lot of asset, you should. But if you don't have asset, you file bankruptcy. Yeah, that's the solution. So one of my friend when I was 20s, this guy was his father was a minister, but his mother does a big business and whole family does business except his father. Maybe that's his business. It's a big church. And mother has the garment factory, and this guy used to have a meat wholesaler. Now father gave him this, established this business for him when he was like 26. I think even before 26. So like we all the friends were, wow. And he acted like, if I say, at the time I think I was in the bank. In the bank I used to drink a lot because customer always treat me drink because I was loan officer. Then I go to, let's say, sauna during daytime because then he's there and seriously he's thinking there, what are you thinking? Oh, now I have a business and I have to think. So he acted like he's a cool person. Then that lasts only for 1 year. Then one of his meat driver, killed somebody.
Oh no.
Yeah. Then his insurance didn't cover everything. So end up filing bankruptcy. then yeah, then I never saw him again. I don't know what happened. So anyway, it happens. So basically, all these damages. Okay, let's go through this. Let's go through this general damage here. 1A, general damage foreseeable from injury. So general damage compensate for those injuries or loss that a reasonable person would foresee, resulting from wrongful conduct. So pain and suffering in personal injury case. Now, since such injury could be anticipated by wrongdoer, they need not be specifically predicted. Special damage is something not foreseeable from injury. So compensatory damage can also be awarded for injury or loss that could not have been foreseen from mere occurrence of the wrong. So wage losses in personal injury case. Now these losses must be specifically pled to give notice to defendant that damage will be claimed for them. Anyway, I always got mixed with this general damage and special damage. I think at the beginning, somehow I always got mixed up. Okay, then on the requirements side, now this is a negligence case, so I don't think we really have to go through negligence element, but whether the compensatory damage will be awarded, a measure of such award depends on each case upon whether damages are. What's our toward the negligence element was duty, breach, causation, and damage. Yeah, here they are talking about more causation matter. So here damage, they talk about but for this. Now there are two type of damage. One is the what was the two type of damage? Was it direct damage or indirect damage? Was it right? Did we call that? But for was we had no, that's not. We had to in causation. There are two types of causation. One is I think direct causation is more, the definition is but for, and indirect causation is more, it has to be foreseeable. So normally.
This is proximate cause.
Oh yeah, proximal cause. What was another one? I think it was either direct or indirect, and I forgot the exact term. But anyway, there are two types of damages, of the causation. Okay. So anyway. Let's not go through all the tort element. So let's go to page. The reason actually this copy is not really full page is because I made a copy from legal side. So top portion and bottom portion, I had to make it letter size. I had to actually divide the page into two. Okay, so let's go through nominal damage. This nominal damage is many times when the damage amount is so little, and most people ask for nominal damage to basically, they are not really filing a lawsuit for damage amount, but they are filing to prove that they are true. I mean, they are right. Maybe such case will be, let's say, Korean Association. Korean Association in California, in LA, or here. But most of Korean Association, they all have a lawsuit. Even for Noinhue too. They all have a lawsuit. Now they are not really filing lawsuit for monetary damage, but they want court to recognize that their presidency is legitimate, means that they are they're true president and other person is not. So whenever somebody try to they're filing a lawsuit to want to get decision from the court that they are the right party, not for monetary damage, we call nominal damage. So even when we actually look at some case law, judge sometimes will say, okay, I'm gonna only award nominal damage, but this is my ruling. So in that case, nominal damage amount is not important, but ruling is important. I think the something like, let's say this was a farmland. I think this happened in California, and before house booming, Los Angeles was not big as right now. So basically around 1 hour radius, Los Angeles were a lot of farms. A cattle ranch. Then when house booming, it was a house booming period, many contractors, builders bought cattle ranch, and they convert the zoning to housing zoning, and then they build the house. Then the problem is after people moved in, they begin to have a smell because there's a cattle ranch next to them. Because this owner of cattle ranch sold, let's say, only half of his land, but he's still raising cattle. So house association filed a lawsuit to cattle ranch owner. Cattle ranch owner, his defense is, I was here before. They bought the land from me, and who asked them to convert that into residential zoning? They asked me to sell the land, and I did, and now I was here from my grandfather, and now you guys filing a lawsuit, and I should be responsible for all the smell. Now if it was a common law, old law, house association lost. The ruling was always, you guys moved in later. Then current approach is, they're trying to find a solution. Now the current approach is, nobody really did anything wrong. Ranch owner didn't do anything wrong. But same for the house owner, it's not their fault that they all these smell. So this type of case, what judge will do is, I will award nominal damage. Let's say 2 house owners. However, if you guys want, okay, I will let you guys win, but you guys don't get that much because you guys moved in later, and that's not his fault. So if you guys wanna get rid of the cattle ranch, you guys buy out his cattle ranch. Well, you guys have to, first you have to buy out, and you have to pay for the moving expenses. So in a way, the ruling was interesting that the judge would say, okay, I will let the house owner win with the nominal damage. So you guys win only $5,000. However, basically cattle ranch owner, he's liable only $5,000. But if you guys wanna get rid of him, buy him out, and you guys have to pay for all the transportation, everything. So he took the somewhere middle. So he's saying both parties, nobody is right or wrong. So that's type of damages. And somebody, when filed a loss for defamation, let's say his proposal is not to really, not for the money, but he wants to regain his reputation. Then yeah, he doesn't really care how much he wins. Then in his complaint, let's say let's say judge will ask, okay, then let's say this was a newspaper company, and this let's say he's a politician, and he asks politician, what do you want from this lawsuit? Then politicians say, I want ruling for me, then I want written apology from this newspaper company, and I want them to put that article in newspaper front page. So basically he's not asking for money, but he's asking for apology and let public know that what they wrote was false. So that's again type of a nominal damage. He wants his reputation back. So nominal damage, that would be nominal damage. Let's say what they said here. Let's say, 7 o'clock. Let's just finish this, then we take a break. It said, in a number of situations, action can be maintained even the plaintiff has sustained no actual injury or loss. In such case, now I think that the case was a trespass to the land, was spitting on plaintiff. In such case, nominal damage may be awarded to establish and vindicate plaintiff right. Such damage may also serve as a peg for awarding punitive damage and cost. Okay. Okay, let's take a break. 7 o'clock.